continued the work of teaching, and therefore they were paid salary by the Honorable Supreme Court. They were directed to दोनों copy. In that case, there were
Just a moment. It is basically a compensation, not salary.
So in this case, your lordship, दोनों copy में चला गया. In this case, your lordship.
We consider. That's all.
Here in this case, your lordship, petitioner's case stands on Annexure 4, 5 and 6. But in Annexure 4, your lordship, petitioner was directed to hand over charge to the particular person. When petitioner went to hand over the charge, he was not available. Thereafter, the direction was given to the petitioner to hand over to the charge to other person, because that person was not available due to some personal difficulty to that person. And for that reason, petitioner could finally hand over charge on 20th June 2020, your lordship. That is all.
There is one vigilance case also pending against you?
That is all.
Yes, Lordship. Lordship, it is not the case. Repeatedly, the petitioner has been given direction to hand over the charge. This way or the other way, that same has not been committed due to no fault of the respondent state law. Kindly see this paragraphs as is written.
Paragraph?
Paragraph.
Paragraph 12?
Lordship. 12, Lordship, and 13. And petitioner has been.
Just a moment.
Para 20, Lordship, also Lordship. This is very important, Lordship. Para 20, page 16. Nowhere it has been written that the petitioner has been allowed to work. Kindly see the Annexure 2, Lordship. Annexure 2 of writ petition, Lordship. Page 22.
Yes.
Lordship, in third serial, Lordship.
He was informed about his date of retirement.
Yes, Lordship.
He was asked to hand over the charge.
when the petitioner went to hand over the charge, there was no person to take the charge. That is our case, and
Just
they
a
have not
moment.
replied to
When
those
did you go
paragraphs.
to hand over the charge?
That I have said, Your Lordship.
Date.
Yes, sir. I have annexed that, Your Lordship.
You were supposed to hand over the charge on the very first day, right?
Annexure, if Your Lordship sees the annexure 4, Your
Pursuant to
Lordship.
annexure 4, what did you do?
Annexure 5, Your Lordship, that is.
Yes. What is it?
I have gone to the place, Your Lordship, but there was no one person to take the charge. Thereafter, annexure 6, they have issued that person was that his father was suffering from cancer. So now you hand over charge to the other person.
Naturally, because you did not comply on that day.
I had complied. I had gone there. That is my case, and that they are saying that you have to first. They have said that you give charge to Arvind Kumar, and when I went to give charge to Arvind Kumar, he was not available. Then I informed them. Now they are saying that Arvind Kumar's father is suffering from cancer. So now you hand over charge to other person. And these paragraphs they have not replied. They have said only that this all retirement benefits have been paid. These paragraphs. And you see their counterfeit lordship. These paragraphs we have mentioned in paragraph 15 to 60, lordship. And what they have replied, kindly see the lordship. Paragraph 14 I have stated, and what they have replied 14 to 15, kindly see. 5 to 19, in para 19 they have said, in reply to para 5 to 19, that after retirement all the admitted retirement benefits has been paid to the petitioner.
After the fact that you did not hand over the charge, did you perform any duty?
Because your lordship.
Did you perform any duty after
I
the
was
age
there, Your
of
Lordship.
superannuation?
I was there.
Or
Your
you were?
Lordship.
Did you work during this period? Were you attending the office during this period?
That's why your lordship he was.
No. It is one thing to say that you were directed to hand over the charge on one or the other date. But were you attending office?
He was custodian.
Were you attending office after retirement?
Yes, that's why.
Yes, from where you say this? That
Because
you were regularly attending the office and performing the duty after retirement. Show me one statement from your petition. That is not there, no? So you have not performed any duty except that you did not hand over the charge. Right?
I could not hand over the charge.
That's right. You could not hand over the charge. But you were not performing any duty. They did not assign you any duty, nor you were attending the office.
That is neither we have accepted or not. They have said that you have not done any.
In
work.
order to claim salary,
Yeah,
you have to show that you have worked during this period, isn't it?
That is missing.
Kindly see page 24 of my counter affidavit, Lordship. 24. Lordship, निवेदन पूरा करना है कि भवदीय ज्ञापन सो एंड सो के आदेश के आलोक में जामताड़ा के भंडार में दिनांक सो एंड सो बजट भवन में भंडार श्री भंडारपाल श्री पिटिशनर लिपिक के से प्रभावित को संपर्क किया। श्री ताले को बताया गया कि भंडार पंची अद्यतन नहीं है। That is the duty of the petitioner, Lordship.
To do the complete.
Yes, Lord.
He did not maintain up-to-date stock,
Lord.
and that is the reason he did not hand over the charge. WPS number 1745 of 2023. Learned counsel for the parties are present. This writ petition has been filed for the following relief. While giving the factual background of the case, the counsel for the petitioner has submitted that while communication dated 21/9/2019, the respondent number 3 intimated the respondent number 4 about the date of retirement of the petitioner, and the name of the petitioner appeared at serial number 3, showing the date of retirement as 31/1/2020. Immediately thereafter, the petitioner on 3/10/2019, within bracket annexure 3, requested the respondent number 4 to arrange for taking over charge of different records which were in his custody. And on 10/1/2020, the respondent number 4 had asked the petitioner to hand over the charge to one Arvind Kumar Mukhraj, Basic Health Officer, Primary Health Center, Jamtara. On 22/1 On 22/1/2020, the petitioner reported that reported to respond number 4 that nobody was present to take over the charge from him. And thereafter, on 28/1/2020, the petitioner was asked to hand over the charge to other person. And ultimately, the charge and ultimately the charge could be taken over by one Gopinath Datta only on 26/2020. Correct? And the no due certificate was issued in favor of the petitioner on 17/2/2020. In view of the aforesaid circumstances, the petitioner is praying for salary for the period from 1/2/2020 to 28/2/2021. The Learned Counsel has submitted that the delay in handing over the charge is fully attributable to the respondents, and therefore the petitioner is entitled for salary even for the period post-retirement till the date of issuance of no due certificate. He has relied upon a judgment passed by the Honorable Supreme Court, passed in the case of C. Rajendran and others versus the University of Calicut in Civil Appeal number 7075-7076 of 2023, decided on 30th October 2023, and the Learned Counsel submits that in the said case, the university's professors continued to teach the students even after the date of superannuation, and ultimately they were entitled to payment post-retirement. The Learned Counsel, appearing on behalf of the respondents while opposing the prayer, has submitted that in terms of Annexure 4 dated 10/1/2022, the petitioner was directed to hand over the charge within a period of 1 week, but the communication to that effect, the communication to the effect that the person who was asked to take over the charge was not available was given by the petitioner only on 22/1/2020. It is not clear as to why the petitioner did not take any step to hand over the charge within 7 days from 10/1/2020. The Learned Counsel has also submitted that the petitioner had given a letter dated 28/1/20, which has been annexed with a counter affidavit, wherein he has shown his inability to hand over the charge in as much as the as he was not prepared with the up-to-date record of godown. The Learned Counsel submits that the delay in handing over the charge is attributable to the petitioner, and further, it is not the case of the petitioner that the petitioner discharged his duties after attaining his age of superannuation. That's it. And therefore, the judgment passed by the Honorable Supreme Court does not apply to the facts of this case. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the petitioner attained the age of superannuation on 31/1/2020 and much prior to his date of superannuation, he was asked to hand over the charge by letter dated 10/1/2020 within a period of 7 days. The writ petition is completely silent as to what the petitioner did within 7 days from the letter dated 10/1/2020. The petitioner on 22/1/2020 informed the respondent number 4 that nobody was present to take over charge from him. The counter affidavit reveals that the petitioner himself was not ready with the up-to-date go-down register, up-to-date record of go-down, as is apparent from the letter annexed with the counter affidavit dated 28/1/2020. Which itself reveals that there was no complete readiness on the part of the petitioner to hand over the charge. The counter affidavit also reveals that one vigilance case being Dhanbad PS case number 4 of 2016 is also pending against the petitioner, in which the trial has commenced, and by memo number 1586 dated 18/9/2019, the civil surgeon cum medical officer Jamtara has also accorded sanction for prosecution, and the retirement benefits, but the retirement benefits has already been paid to the petitioner. It is not the case of the petitioner that it is not the case of the petitioner that even after attaining the age of superannuation, the petitioner has been attending the office regularly and was assigned any work whatsoever. This court finds that in the aforesaid circumstances, the fact that the petitioner was not ready to hand over the charge, was not completely ready to hand over the charge on 28/1/2020, as is apparent from Annexure A to the counter affidavit, and also the fact that the petitioner neither attended the office nor discharged any duty after his attaining the age of superannuation. This court is of the considered view that the petitioner is not entitled for the relief as prayed for in this writ petition. So far as the judgment passed by the Honorable Supreme Court in the case of C. Rajendran and others is concerned, the same is clearly distinguishable in as much as the professors had been attending the teaching work even after their retirement. And the Honorable Supreme Court was of the view that the appellants who were the professors who were the appellants before the Honorable Supreme Court were to be duly compensated, were to be suitably compensated for the extended period of performance of their duty. In view of the fact that the petitioner, in view of the aforesaid facts and circumstances, the judgment relied upon by the petitioner is not applicable to the facts of the case. Consequently, the present petition is hereby dismissed.
Item 2. WPS 1799 of 123.
My lord, the promotional benefit according to the petitioner was not calculated by fixing his compensation, pension. He was promoted to the post of tracer in the year 1995. Annexure 2 at page 20.
Yes.
And thereafter, my lord, he is promoted from service in 2008. And the petitioner contended that since the post of tracer is a technical post, therefore any other job could be assigned to him so that he could perform the duty. In process, the respondent never expedited the contention of the petitioner. He also approached the court. High Court, my lord, direction was given, but no order was passed.
Where is the direction of the High Court?
He
To shift him from treasurer to other post.
My
Where
lord.
is the direction of the High Court to this effect?
My lord, at page 15, at page Annexure 5, Annexure 1, my lord, page 14.
Was it? What is Annexure 1? This is basically the liberty granted, the records were not traceable.
My lord.
Where is the direction of the High Court? You said that High Court directed that he should be suitably shifted, and then
My lord,
where
the
is that direction?
The petitioner continuously approached.
The fact remains that you never joined the promotional post. Did you join? Did you discharge your duty at the promoted post? No.
My lord, that was not assigned. I was altogether in attendance. I was altogether in attendance.
You were saying that since you are not technically qualified,
My lord.
the post is not correct, you should be shifted to another post.
But the promotion was given to me.
But you did not join. You are entitled to the promotional benefits or the promotional things only when you join the promotional post. You never joined the promotional post. Then, how can you claim the benefit of a promotional post? And in the year 2007 also, when you filed the writ petition, you see what is your prayer? The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner was granted promotion by letter dated 31/7/1995, Annexure 2.
My lord. My lord.
Right. Letter dated 31/7/1995 to the post of tracer within bracket Infructuous bracket rules in terms of order passed by the establishment committee meeting against the existing vacancies in the pay scale of rupees 975-25-1150-30-1500 and an official order to that effect was the order dated 31/7/1995 within bracket Annexure 2. And the petitioner was directed to join the promotional post of tracer at Jamtara. However, the petitioner had objection in connection with the promotion granted to the petitioner, as the petitioner contended that the said post is a technical post for which certain technical qualification is required, And since the petitioner was not having such technical qualification and experience to do the office work of tracer, and therefore he made representation to work on the same promotional post of lower division clerk, which was vacant and was equivalent to the post of tracer. The petitioner has annexed copies of the रिप्रेजेंटेशन तो एक भी नहीं लगाया है, रिप्रेजेंटेशन तो नहीं लगाया है.
Several representations.
Where is it? Show me one. Annexure 3 series. In your writ petition, you say Annexure 3 series.
All the correspondence.
No, no, you just say Annexure 3 series, you say representations. Page number 21. Okay.
My lord, page 28, my lord.
Okay. The Annexure 1, no, page number 21 is not your representation.
That is also 25.
What is
my
the
lord.
date of your
Yes,
representation?
25, my lord.
This is 1988.
Yes.
28.
It is prior to your promotion. This is 1988.
Time is, my lord, page 25, my lord.
25. What is the date? 2001.
87 से करिए लेखा लिपिक के तौर पर प्रोन्नति देने
2001 is there. After 1995, there is no immediate representation.
except 20 page 28 में भी है
28 is also 2001.
2004 का है वो.
एक भी रिप्रेजेंटेशन आप 1995 के बाद का नहीं लगाएं, right? Not there. By the time I dictate my order, you just find out one representation immediately after 1995. For which he filed representation. It is the case of the petitioner that the petitioner was granted promotion pursuant to the order passed by Honorable Patna High Court in CWJC number 5252 of 1987, whereby the respondent Superintending Engineer Dumka was directed to consider the case of promotion of the petitioner. The grievance of the petitioner is that though the petitioner was given promotion, but to keep him away from the promotional post and monetary benefit, he was intentionally promoted to a technical post for which the petitioner was not eligible. It is this further case that one similarly situated person who was junior to the petitioner was given the promotional post of lower division clerk with effect from 1988, but the petitioner was never given promotion to the post of lower division clerk, which was equivalent to the post of tracer. The Learned Counsel has also referred to the order dated 23/11/2022 passed by Honorable Patna High Court in civil jurisdiction case number 5698 of 1988, wherein it has been recorded that the registry had put up a note that the record of the writ petition of 1988 was not available, and if the point was still available, then the petitioner may move appropriate application annexing a copy of the writ petition along with entire pleadings so that the main petition could be reconstructed. The petitioner has also annexed a copy of the order dated 28/1/2008 passed in WPS number 987 of 2007, wherein the petitioner had raised a grievance to consider and promote him from the date on which juniors to the petitioner was promoted, and the said writ petition was disposed of to consider the representation of the petitioner. The petitioner admittedly attained the age of superannuation in the year 2008. Upon a query by this court, the learned counsel for the petitioner has fairly submitted that no representation has been placed on record immediately after the issuance of the order of promotion dated 31/7/1995, and the earliest representation on record is of the year 2001.
Correspondence is there, my lord.
Where is it?
Representation is not there, my
Not.
lord. But the
We are not
correspondence is there. All the state authorities, my lord.
Yes. From the perusal of after hearing the learned counsel for the petitioner and going through the materials on record, this court finds that the petitioner has been fighting for his promotion, and a writ petition was filed being CWJC number 5257 of 1987, which was disposed of which as per the petitioner was disposed of with a direction upon the concerned authority to consider the case of the petitioner for promotion, and ultimately the petitioner was granted promotion in the year 1995 by Annexure 2 dated
31st July 95.
dated 31st July 1995. The petitioner did not join the promoted post and had objection in connection with the promotion granted to the petitioner, inasmuch as the petitioner contended that the post on which the petitioner was promoted was a technical post and the petitioner was not qualified to attend that post. And the petitioner insisted that the petitioner should be given promotion to the post of lower division clerk,
Equivalent to the post of tracer.
which was equivalent to the post of tracer. This court further finds that after bifurcation of the state of Jharkhand, the petitioner filed a writ petition before this court, being WPS number 987 of 2007, wherein the petitioner sought a direction upon the authority to consider and promote him from the date on which his juniors were promoted. And it was his case that his juniors were promoted and the petitioner and the case of the petitioner was not considered. The said writ petition was disposed of by the order dated 28/1/2008, enabling the petitioner to pursue his representation before the competent authority. From the perusal of the order dated 28/1/2008, passed in WPS number 987 of 2007, it appears that even at that stage, the petitioner did not agitate his grievance regarding his promotion to the post of tracer instead of lower division clerk. And his grievance was only in relation to grant of promotion to the petitioner, ignoring to the juniors to the petitioner, ignoring his case. This court finds that admittedly the petitioner did not join the promoted post, and in the records of this case, a representation of the year 2001, the earliest representation in connection with the promotion granted on 31/7/1995, which has been placed on record, is of the year 2001. Such grievance of the petitioner was not even agitated by him by filing the subsequent writ petition, being WPS number 987 of 2007. In view of the fact that the petitioner was promoted to the post of tracer, to which the petitioner did not join, and ultimately he has attained the age of superannuation, no relief can be granted to the petitioner as prayed for in this writ petition, which is accordingly dismissed.
Item 3, WPS 2090 of 2023.
Yesterday,
Does the appeal lie?
no, appeal will not.
The learned counsel for the parties are present. No appeal?
Your Lordship, there is the provision of appeal, but the final order of punishment has been passed by the highest authority. So in that eventuality, Your Lordship, he cannot prefer an appeal.
Okay. The learned counsel for the parties have jointly submitted that the petitioner does not have an alternative remedy of appeal. The learned counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case. Let the counter affidavit be filed by 7th March. By 7th of March. Rejoinder by 11th.
1 week time maybe.
14th. Post this case under the heading for final disposal on 18th of March. Next. The parties will also file their synopsis and list of bills, and the judgments which they seek to rely upon.
From dailies for orders, item 27, WPS 2685 of 2023.
There are surviving defects in connection with certain pages.
Yes, sure. Probably annexure 2.
This is page number 172, 190 and 191.
When on last bill, the petitioner was directed to furnish a fresh copy of annexure 2.
Yes. So let us ignore it for the present, subject to any objection from your side. They will not, are not reliable, hence they don't want to rely upon that.
Your Lordship, the Union of India is the main party for state of. So I cannot give this.
Petitioner absent.
Sorry, board देख रहे थे 26
बोर्ड में अलग आइटम बता रहे हैं. हाँ बताइए क्या बोलना है?
My lord, I have filed one IA.
Do you want to rely upon these wages or you don't
No.
want?
Rely but not available.
Not available, so from where do we get it? If you want to rely upon a document, you have to remove the defects.
So.
It can't be like this, no. You cannot rely upon a document which you also cannot read.
Yes, a very attempt, but
You
not
delete
any-
it. You delete it from the records. That I will permit. Or you remove the defects. You do whatever. We can't do anything about it. What do you want? You want to delete it?
Yes, delete.
WPS number 2685 of 2023. With IA number 2078 of 2024. The learned counsel for the petitioner has submitted that he is unable to remove the defects in connection with page number 172, 190 and 191. He submits that he shall not rely upon the said documents. Considering the aforesaid submission, IA number 2078 of 2024 is allowed. The petitioner is directed to delete page number 172, 190 and 191 in red ink during the course of the day. उसको delete करिए, आपको पढ़ने नहीं देंगे डॉक्यूमेंट, ठीक है? Hearings are complete.
Lord, we have already filed counter affidavit of the matter related to the appointment of 2013.
It has become infructuous.
No, Lord, they will challenge, Lord. So far as the last cut-off date, they are asking that they have qualified the examination, but they have not been appointed in spite of the seat itself, Lord, according to them.
That's right.
But so far as the counter affidavit which has been filed, Lord,
They did not.
the ST category of candidates, Lord, the seat was fulfilled, last candidate marks, the petitioners have got lesser than that, Lord. This is the simple case.
In view of the aforesaid fact, IA number 2078 of 24 is allowed. Post this case tomorrow under the heading fresh file.
इसमें IA early
IA for early hearing is allowed. There's one more IA.
For fresh filing item 28, WPS 42 of 2023.
WPS number, बताइए क्या बोलना है आपको?
For setting aside the letter number 2555 dated 6/12/2022, annexure 9, by which the grievances of the petitioner.
What do you have to say?
Counter and
You can't say anything from the records.
There is a mention is the Sankalp Sankhya, Lordship. In view of that, his grievances have not been addressed.
Lordship,
That is not annexed.
WPS, that is not annexed.
Annexed in
Annex-
it should be annexed with counter.
अनेक्ट है लॉर्डशिप, इसमें जो ये बता रहे हैं ये 10/483/4414 का कोई रिजोल्यूशन नहीं है जिसके चलते ये कह रहे हैं कि नहीं दे रहे हैं। हम रिजोल्यूशन अनेक्स किए हैं लॉर्डशिप।
WPS number 42 of 2023. Counsel
Annexure
for
number
the respondents
55 pending.
praise for and is granted time till 7th March,
1 week more.
14th March 2024 to file a counter affidavit in the present case. Rejoinder, if any, by 21st. Post on 9th of April under the heading for admission.
Item 29, WPS 91 of 2023.
Reviewed order is at page number 33, my lord. My case of appointment has been rejected on the ground, my lord, that under NCWA, the appointment or compassionate ground is available only to a permanent employee of the company, my lord. Now, my lord, I was reinstated in the year 2016 after my removal from service, my lord. And one of the terms and conditions of reinstatement order was, my lord, that
No,
my,
you are seeking what?
my lord, compassionate appointment.
Compassionate, you were reinstated.
Yes, my lord, I was reinstated.
You were granted compassionate appointment.
No. I was after dismissal in the year 2006.
Who was dismissed?
My father was dismissed.
So you talk about your father? No, you are talking about yourself.
Yes, my lord, sorry.
When was he dismissed?
2006, my lord. Removed, my lord. He was removed from the service on 16/2/2006.
Okay, then
Then he was reinstated
on
in the year 2016, my lord,
date.
by the order dated 11/5/16.
Okay, then
My lord,
he continued.
I joined employment, my lord, and I worked as a permanent employee. This was the condition.
I means what? You are the petitioner.
Sorry. Petitioner's father worked, my lord. As a permanent employee of the company. He was even sent on deputations to the other
No, you
place.
forget it. This particular reinstatement
My lord,
in the year 2016. When
16.
did he expire?
he died on 16/12/20, my lord.
He was reinstated as a badli worker.
Badli worker.
He was never regularized.
No, never regularized.
So so
I will draw your kind attention to the reinstatement order, my lord.
where is it?
It is at page number 23, my lord.
Yes.
Para number, serial number 12, my lord. The service of Sri Ganesh Gorai upon reinstatement shall be governed by the provisions of NCWA and the certified standing orders of the company. My lord, NCWA does not differentiate for compassionate appointment a
Are you
permanent.
relying upon any judgment?
No, I do not have any judgment at present.
I have a judgment.
Give me the judgment. Show me the judgment.
I will file counter.
You don't need to file counter. Show me the judgment straightforward.
Judgment of LPA.
273.
393, Lordship. There is, in this case, there is no automatic
Reinstatement. Whether this is in relation to NCWA?
Yes. Nothing like automatic confirmation.
Where is it?
Lordship, I refer page 9, Lordship, page 9, and
Page 9.
page 11, Lordship.
Page 11. Okay. Confirmation is another thing. Badli workman is another thing.
Yes, Lordship. He is not confirmed, Lordship. He is never confirmed. Lordship, in his
ठीक है, लर्नर काउंसिल कल भी एक आ रहा है बदली वाला, राइट? उसके साथ ही सुनेंगे. कल आ रहा है ना एक मिस्टर A.K. Das is there. I think tomorrow it is coming.
It will be just and proper if they file a counter because it requires interpretation of National Coal Wage Agreement.
That has already been interpreted in your favor by the division bench, but you do not know. That is the whole tragedy, that you do not know your own judgments of our own High Court. You are not aware.
Lordship, in clause 9, Lordship, the date of reinstatement of Sri Guru shall be treated as date of his fresh appointment.
Fresh appointment for the
And
purpose of
Sri Ganesh Guru shall be engaged as a badli worker in place of permanent workman.
fresh appointment.
So my contention is that he is never confirmed, Lordship.
Fresh appointment was only for the purpose that no past services will be taken into account for retiral dues. That's all. And there
You show
cannot
me from this judgment that it was a case of badli worker. Show me from this judgment.
ये बदली वर्कर का नहीं.
नहीं है ना? तो फिर ऐसा काम नहीं करिए ना. Don't try to mislead the court in this manner. You examine this order. LPA 273 of 2020 decided on 30th August 2023. साथ में इनका रिट का भी रिकॉर्ड आप देखिए. सेकेंड हाफ में आइए क्योंकि कल तक तो आप एग्जामिन आपको टाइम कहाँ मिलेगा पढ़ने लिखने के लिए.
कर लें.
आप सेकेंड हाफ में इसको पढ़ के आइए और लर्नेड सिंगल जज का भी ऑर्डर पढ़ के आइए. तब हम इसको कल के लिए रखेंगे.
LPA
LPA number 273 of 2020 decided on 30th August 2023. It is arising out of an Industrial Disputes Act. The learned single judge has interpreted the provision of NCWA as well as the provision of standing orders and has said that for the purposes of this relief,
Lordship, in this case, NCWA provision is interpreted in this case.
आप एक बार पढ़ के आइए second half में. Right? Come.
259.
Yes, come at 2. You also see this judgment. See the corresponding judgment of the Honorable Single Judge.
And so far as the permanent lordship, confirmed, there is Supreme Court also said there is no permanent automatic permanence lordship.
You talk about Supreme Court judgment without bringing it. So that is why you do whatever. You bring it to the court, we will see what is to be done. I am giving you 2-3 hours time.
Item 30, WPS 207 of 2023.
Okay, Passover. Passover will be taken up at 12 o'clock.
Item 31, WPS 213 of 2023.
The matter relates to advertisement of year 2004.
So,
Advertisement in Jharkhand police.
it has become infructuous.
Still the posts are vacant.
No, we can't. 2004 vacancies against this we can't do.
That is there, ma'am. Therefore, at the outset, I have stated so that my advertisement is of year 2004. But my lord, my submission is this, that still the posts are vacant.
No fresh advertisement has come after 2004?
That has come.
That has come. Okay. WPS number 213 of 2023. Counsel for the parties are present. This petition has been filed for the following relief. The counsel for the petitioner has clearly submitted that the matter relates to advertisement of the year 2004, and upon a query of this court, the learned counsel has also submitted that there has been subsequent advertisement to fill up the post.
This may come from the mouth of others.
It has already been time barred in the 2010 and subsequent many advertisements.
The learned counsel for the respondents has submitted that no relief can be granted to the petitioner inasmuch as there has been numerous advertisements and the petitioner is seeking relief in relation to the advertisement of the year 2004. After hearing the counsel for the parties and considering the submissions, this court is not inclined to grant any relief to the petitioner in relation to the advertisement of the year 2004. The fact remains that the post has been subsequently advertised as submitted by the counsel for the petition. The petition is accordingly dismissed.
Item 32, WPS 214 of 2023.
Yes, petitioner.
For the same order passed by this honorable by lecture 4 years. This is a preparation of service lecture. The professor is working in a bank, State Bank of India, from since 1990. And also his matter has been considered
Annexure
by
4.
lecture 2.
Annexure 4, where is annexure 4?
Lecture 2. The same order passed by this honorable in a batch of cases. This is carried upon further.
पेज नंबर बताइए ना आपका
My
इलेक्शन
lords, page number is 34, my lords. It starts from 34.
Page 34.
34.
What's relevant page number 34?
Any adverse order passed against you?
He looked against me that one single
He was
person,
not petitioner
Sapan
in
Harjan.
that case. He was not the
That's
party.
right, he was not the party,
I am
but
not the party, but one Sapan Harjan who was party against the bank. Then this honorable could heard the matter and directed the concerned bank to exercise that within period of some time. If I will order, the Sapan Harjan is the same.
has your candidature been considered? Have they passed any adverse
No,
order
they have not
against
passed
you?
any order.
You go and represent before them. You
have
consider
dependent
his
matter.
representation.
Yes, yes.
Milord, moreover, Milord, he is seeking regularization, Milord,
As
after
per-
attaining
as-
the age of superannuation.
I am
And
71.
moreover, one more
Date
thing,
of birth
Milord,
was
he
71.
was under employment of an agency, Milord. He had himself stated in
Where is it?
para 10 page 17. para 10 देखा जाए मुझे. ये regularization का prayer कर रहे हैं 60 years के बाद.
Date of birth is
para
1971.
70.
Through agency, namely.
हाँ.
See, making of payment to the bank.
और ये जो जजमेंट जो कोर्ट किए हैं उसमें भी है कि जब टर्मिनेशन हो जाता है इनका पैरा ये पेज 41 में देखा जाए राजबल्लभ प्रसाद का जजमेंट है 2018 सुप्रीम कोर्ट का पेज 41. The Honorable Apex Court in the case of Rajballabh Prasad and others in the state of Bihar and others reported in 2018 one Supreme Court was of the view that the regularization cannot be claimed while in service can be claimed while in service not after termination and appointment of a temporary period.
When did he attain the age of superannuation?
He cannot file any counter affidavit.
When
My
you
date
don't
of-
need to file a counter affidavit.
My date
You
of
just
birth is
satisfy the court
1971.
parameters. When did you attain the age of superannuation?
Lord, may kindly see
71,
the age
1971.
71 date of birth.
नहीं वो तो गलत है.
When did you attain the age of superannuation?
In 31. 2031.
हुजूर इनका अपना सेल्फ डिस्क्लोज देखा जाए जो फर्स्ट पेज पे जो पेटिशनर का वो होता है डिटेल होता है.
Yes.
हल्धर धोली aged about 60 years. He has himself disclosed his age. Petitioner का पहला after very first page of the petition.
Just a moment. Petitioner to the post of sweeper under respondent number 6 since 1994 onwards till 2017. He has worked only till 2017. So you are not in service as of now.
No, I am service.
From where do you say that you are still doing the work?
By the enacted file also.
You tell it from the petition that you are still continuing to work.
No, we have stated by enacted.
Para 14 you say. What is para 14? मेरी जगह किसी और को बहाल कर लिया गया है. You have been discontinued in 2017.
Yes, 2017, no, 2022 I have made the salary. Enacted file is there also. The salary certificate is there.
You see your representation.
Can you see the enacted
You
file?
see your representation.
Yes, the patient can you see also enacted
You see, read
file?
your representation, please. Page number 53.
Yes, can you see also?
Read your representation, page number 53. Read it.
51 is also considered.
You read 53.
51 is also.
51 में भी तो वही चीज
सेम चिकवास 20 वर्षों से काम कर रहे हैं.
आप पढ़िए ना पेज नंबर 50.
कर रहे थे पहले दूसरे का
कौन सी भाषा में आपको
जो
समझ?
भी एक युवक मैं लगभग 20 वर्षों से भारतीय स्टेट बैंक बजट बयान पेपर का काम करता था.
काम किया.
मैं मानदेय में लगभग 20 वर्षों से काम किया. जब सरकारी बहाली होती उस समय बजट बैंक में तहसीलदार लोग जाने वाले एक बसने वाले से दीपक ठाकुर पिता मुख्य मुझे झूठ बोलकर ज्यादा हम अपना नौकरी करा.
आप पेज नंबर 53 नहीं पढ़ेंगे.
53 जो
If you will not read it, I will quote page number 53 and dismiss your case.
53 is also there.
You read
Before the
page
bank.
number.
Before the bank.
Yes.
सबने पूर्वक कहना है मैं से हल्दर दो भी स्वर्गीय सचिव सा जिला बारह साहिब निवासी मैं वर्ष 94 से 2017 तक बजट बैंक में सुपर काम करता आ रहा था. परंतु इसी बीच जब सरकारी नियुक्ति बहाली काम हुआ तो मेरी जगह में किसी दूसरे का बहाली कर दिया. जब मैं शाखा मेरे पास खोला तो कहा कि तुम्हारी जगह दूसरे का बहाली कर दिया है. जबकि मैं लगभग 20 वर्षों से.
So you have been discontinued since 2017. No means what?
But the record says, the statement says that I have received a salary.
WPS number?
Lecture 5 is there.
Show me one document from the record that you are still working.
Can you say lecture 5 also? Page 50,
Page number
55.
50.
The statement of the bank.
Yes.
Fine.
Yes.
Page 50, last salary slip 3,200.
Save Solution Private Limited input salary.
कहाँ है? Where is it?
यहीं पे है 5/3 को मिला है
Serial number?
किया गया है 5/3/22 को भी
2022.
5/3/22 को भी देखेंगे उसके बाद 6/4/22 को भी देखेंगे
कोई
Now
Save
the
Solution
bank
का
has-
लगा है.
bank has given the supervisor the bulk of the security to the agency but I am the silver from 2022
Save Solution इनको सैलरी दे रहा है.
कहाँ काम कर रहे हैं बैंक में ही काम कर रहे हैं कहीं और तो नहीं हो
कोई डॉक्यूमेंट थोड़ी.
You have to file complaint. Then you can say they are not working in the bank.
Other persons have been regularized.
The supplement, I have referred again supplement artisan whom before this only, and this question has directed the bank to consider again by one-time wages. They either reject me or allow my application. Otherwise, that is the case of lecture.
I will record whatever he is saying. I'll record whatever you are also saying. You consider and pass an order. If there is an applicable policy of the bank for regularization, you do whatever. Check your records and do it. Right? Because there is no adverse order.
As such, there is no. But he is still in continuation in the service.
We will record it.
Yes.
That is no paper.
WPS number 214 of 2023 heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner has been working as sweeper in the respondent bank during the period from 1994 to during the period 1994 onwards till date, and has not yet attained the age of superannuation, and therefore the petitioner is entitled for regularization. The learned counsel for the petitioner has also
Daily
submitted
wages-
that
Daily wages what? They
The
have
petitioner-
they have stated that I am working at daily wages.
just a moment. The counsel for the petitioner has also submitted that the records of the bank show that payment is also being made directly to the petitioner. Inasmuch as in page number 49, the payment is shown in the name of the petitioner, amounting to rupees 1,500. Right? He submits that this document is enough to show that the petitioner has continued to work and is still working. The learned counsel has referred to a judgment passed by this court in WPS number 7755 of 2017 and submits that another person who was also working in the bank was granted the benefit inasmuch as this court had passed the order directing the respondents to examine the individual status of each and every petitioners of the state case in accordance with law, and if there is no legal impediment, pass a speaking order assigning concrete and valid reason considering non-consideration of the case of the petitioner for regularization. The learned counsel submits that similar order may be passed in the present case. The learned counsel appearing on behalf of the respondent bank has opposed the prayer and has submitted that no counter affidavit has been filed in the present case, but the records of the case indicate that the petitioner was engaged on daily wage and
through same solution private limited.
and has been working through an
Working
agency, namely Save Solutions Private Limited. The Learned Counsel has referred to paragraph 10 of the writ petition. He has also referred to para number 14 of the writ petition to submit that the petitioner himself has stated that he has worked in the post of sweeper under respondent number 6 since 1994 onwards till 2017. He has also referred to the representation of the petitioner as contained in page number 53 of the writ record to submit that even in the representation it has been stated that he has worked only till 2017 and subsequently in his place another person has been appointed.
My lord, the case of Rajbalam Prasad.
The Learned Counsel has further
Page
submitted
41,
that in the judgment passed by this court in WPS number 7755 of 2017, this court has also considered the judgment passed in the case of Raj Balam Prasad versus State of Bihar, reported in 2018 within bracket 1 bracket close Supreme 12, to submit that the question of regularization can take place only if the person is still working. He submits that the case record itself indicates that the petitioner has attained the age of 60 years as is mentioned in the cause title of the writ petition, and therefore the petitioner has already attained the age of superannuation. He is not entitled to any relief as prayed for in this writ petition. After hearing the Learned Counsel for the parties and considering the aforesaid submissions, this court finds that there are disputed questions of facts involved in the present case, and from the perusal of the writ records, it appears that no adverse order has been passed against the petitioner. This court is of the considered view that if the respondent bank has any scheme for regularization and if the petitioner fits in the said scheme and is still working, there can be no impediment in passing a reasoned order with regard to the claim of the petitioner. Right? Accordingly, this writ petition is disposed of, enabling the petitioner to approach respondent number
4, my lord, regional manager.
Respondent number 4 within a period of Bihar.
बिहार के लिए भागलपुर का ही रीजन लिखे हुए हैं, लेकिन ये पाकुड़ में आएगा हुजूर रेस्पोंडेंट नंबर 5
to the respondent number 5 by a detailed representation along with a copy of the writ records. Upon filing such representation, the respondent number 5 shall verify the concerned record and pass a reasoned order after granting an opportunity of hearing to the petitioner. The reasoned order be passed within a period of 3 months from the date of representation and be communicated to the petitioner through speed post. This court has not gone into the merit or otherwise regarding the claim of the petitioner. It is for the respondent to consider the same in accordance with applicable policy of the bank.
Item 33, WPS 216 of 2023.
Yes. What do you want?
Some time, ma'am.
Adjournment. What is the prayer?
petitioner is praised for giving the promotion as grade 4 from the year 13 and 7 from the year 13. He is already retired, Lordship, and at best he could claim notional promotion, but he is claiming promotion.
When did he retire?
Sorry.
When did he retire?
He has not mentioned, but in page number 1 he has mentioned his age as 67 years. Otherwise, in the counter we have mentioned that no post was available, so promotion was not given. So
If the
unless
post
there
is
is a
not available, then it is not his case. His junior has been promoted.
he is mentioning that he has mentioned in his petition that similar situated person has been given promotion, and he has also written in his petition that illegal gradation list has been prepared, but
That is not under challenge.
That is not under challenge.
You don't have a case, Master. So you want to argue today, or you want to argue tomorrow? Yes, you argue. Argue your case. You can argue it tomorrow also, because we are still with time. Right? You have heard him. You have heard what he has said. Right? Counsel for the parties are present. Pose this case tomorrow. If you don't come tomorrow, we will pass the order. We will not wait for you.
Tomorrow.
At the request of the counsel for the petitioner.
Item 34, WPS 237 of 2023.
Petitioner,
What's the playing for some time?
short adjournment. Why?
Senior is not there. No,
Short adjournment means second half.
no one, any day after.
Short after?
Tomorrow.
Tomorrow? Counterfeit?
Yes, madam.
WPS number 237 of 23, counsel for the parties are present. At the request of the petitioner, pose this case to
Item 35, WPS 333 of 2023.
Matter is to quashing of annexes 12. It is an order by which claim of the petitioner for compulsory apartment has been rejected.
Annexure 12,
At page 114.
114. Can you read the
Yes.
order?
Stating that,
It starts at page number 113. Dated 21/20.
yes, 21.
What is the ground? You just tell us the ground. Why they have rejected it?
On two grounds, Lord. On the ground of limitation, as well as the mother of the petitioner has opted Form 1. Form 1 of the scheme says that if any widow of the deceased employee opted Form 1, then she will be entitled to get only pensionary benefits, not the compulsory appointment. So on the two grounds, Lord,
One is Form 1
and second is on the point of limitation.
on the point of limitation. When did the employee die?
Died, Lord, in the year 1993, Lord.
24th October 1990.
What is this? No merit in
Yes,
this
sir.
case.
At the time, the petitioner was remanded.
So
6
you
years.
have a vested right for consideration
no,
of
no.
compassionate appointment
No.
after you attain majority. Then the unborn child will also claim compassionate appointment. Yes, possible. Why not?
My lord,
If a child
My
is
right-
yet to be born, you can claim.
my right accrued through, my lord, by the order of this Honorable High Court. I had also approached before
Where is
earlier, my
that?
lord.
Where is that order?
Page 77.
Page 77, my lord. Respondents were directed to pass order afresh. by this order, claim of the petitioner
Only
was-
a mandamus was sought for, no? There was no adverse order against him. Right?
But
You see, without having gone through the rival submission,
by this order, my lord, the claim of the petitioner was rejected, my lord. But this application was filed by the mother of the petitioner, my lord. And the scheme says, my lord, only son and daughter are eligible.
this was filed by the mother of the petitioner.
Yes.
She was claiming compassion.
Yes, yes,
So her claim was rejected.
rejected.
So now you want that it should be given to you. Very good.
Taking the advantage of the scheme, my lord. Scheme says, my lord, that only son and daughters are eligible for getting the benefits of under compassionate appointment, my lord. So it was erroneously applied by the mother of the petitioner.
Give me the dates. What is the date of death?
Date of death, my lord, 24/10/93.
20 or 24?
24.
It has been mentioned in the earlier order 20/10/93.
The impugned order says 24.
Okay. Let us take 24/10. Now, mother moved the High Court
Yes, ma'am.
for seeking compassionate appointment.
In the year 2016, my lord.
That's right. And let us see the impugned order.
Yes, ma'am. Where is the law?
Okay, delay we can understand. Is there any time frame for applying for compassionate appointment?
Yes,
What is the time?
3 years, ma'am.
What was your age at the time of death?
8 years, ma'am.
That's all?
9 years, 9 years.
That's all? Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the father of the petitioner had expired on 24/10/1993, and thereafter the mother of the petitioner was seeking compassionate appointment, and ultimately her claim for compassionate appointment was declined by this court. And when no order was passed, she had approached this court in WPS number 4341 of 2016, which was dismissed by this court by the order dated 24/3/2017 within bracket annexion 9. The learned counsel submits that as per the scheme of compassionate appointment of the respondents, only the son and daughter are entitled for compassionate appointment, and therefore the petitioner applied for compassionate appointment after dismissal of the writ petition filed by the mother of the petitioner. The learned counsel has, upon a query of this court, the learned counsel has submitted that on the date of death of his father, he was 8 years,
9.
9 years of age, and upon attaining majority, he has got a right to apply for compassionate appointment. The learned counsel has submitted that the claim for compassionate appointment has been rejected on 2 grounds. One is relating to the fact that an option was exercised in Form 1, which entitled the mother to claim pensionary benefit, and by virtue of such entitlement of pensionary benefit, the compassionate appointment was excluded. And the second reason for passing the impugned order is that the application is a belated application. As the stipulated period for applying for compassionate appointment is 3 years from the date of death. The learned counsel submits that since the mother of the petitioner was pursuing for compassionate appointment, and after the dismissal of the writ petition, the right accrued to the petitioner to apply for compassionate appointment, and therefore the impugned order calls for indifference. The learned counsel, appearing on behalf of the respondents, on the other hand, while opposing the prayer, has submitted that the parties are governed by the scheme, and as per the scheme, the mother had opted for pension, and therefore none of the family member was entitled for compassionate appointment. He has further submitted that the petitioner was admittedly a minor at the time of death of his father, and no right crystallized in favor of the petitioner, and no right stood vested in his favor to claim compassionate appointment once he attains the age of majority. The time period is for applying for compassionate appointment is
3 years.
3 years from the date of death.
But the scheme says it's only 6 months. It says 6 months.
Okay. The Learned Counsel has further submitted that the scheme stipulates only 6 months. After hearing the Learned Counsel for the parties and considering the facts of this case, admittedly the father of the petitioner had expired on 24/10/1993, and at that point of time the petitioner was a minor and was not entitled to claim any compassionate appointment. The mother of the petitioner was pursuing for a compassionate appointment, and after a long gap she filed a writ petition being WPS number 4341 of 2016, and the said writ petition was dismissed by the order dated 24/3/2017, holding that she was not entitled for, she did not deserve compassionate appointment, and by recording the finding as under para number 5, page number 79. This court is of the considered view that no fresh cause of action accrued to the petitioner by virtue of the order dated 24/3/2017 passed in WPS number 4341 of 2016. Further, the petitioner was minor, and on the date of death of his father, no right crystallized, and the petitioner does not have any vested right to claim compassionate appointment. Further, the father of the petitioner had died way back in the year 1993. The whole purpose of the compassionate appointment has this court is not inclined to grant this court does not find any illegality in the impugned order, which has rejected the claim of compassionate appointment on both counts. As per the scheme, once the person opts for pensionary benefit, there is no question of grant of compassionate appointment. The state petition is accordingly dismissed.
Appearance is 0.
There will be certain corrections in the order, but the contents of the final order will be a dismissal.
Password case item 30, WPS 207 of 2023.
Where is the petitioner? He wants quashing of the entire departmental proceeding. We will dismiss it here and now.
Memo of charge he has challenged.
We have also filed a petition for vacating the stay.
IA has been filed for necessary correction.
Necessary correction where?
For making correction the prayer and relief portion. He has prayed for
7506. What correction? What correction is seeking?
He's seeking paragraph 3 has stated that that stamp reporting has prompted documents which are under challenge as stated para 1 para has not been filed. Verified. With regard to the typographical mistake in the first paragraph, relief portion, main application, inadvertently he has mentioned circularly for quashing. He is not praying for quashing instead of praying for a mandamus.
There is a prayer for quashing of
He
the
has
entire
been-
department.
But in the IA, he quashing one prayer is prayer 1. If Lordship may kindly see, he has prayed for particularly in the nature of certiorari for quashing the sanction leave availed by the petitioner.
So he's claiming that he's not praying for a quashing, he's praying for mandamus instead of.
He has corrected it by stating mandamus. This has been listed for orders.
Not sure, it's
No.
fresh.
It's fine.
Fresh. The counsel for the petitioner is absent. Today is 27, in spite of repeated calls. On 5/2/2024, time was granted till 22nd February 2024 to remove the surviving defects. And it appears that the defects have been removed and the matter, it was also directed that if the defects are removed, the case will be posted on 27th February 2024. Today, when the case is taken up, though the matter has been listed for fresh filing, but the petitioner is absent. After going through the prayer by the writ records, and particularly the prayer made by the petitioner in this proceeding, it appears that a charge memo has already been issued to the petitioner. It appears that the petitioner is inter alia praying for quashing of the entire departmental proceeding, including the memo of charge issued to the petitioner contained in memo number 1181 dated 22/7/2022, issued by respondent number 4. The charge memo, the allegation against the petitioner in the charge memo and its allegation is contained at page number 182. 182 mein hai?
Yes.
Which relates to his absence from duty during the period from January 2022 to 9/3/2022 without any prior intimation. And other related acts and omission. And there are altogether 12 allegations leveled against the petitioner. This court is of the considered view that the charge memo has already been issued to the petitioner, and considering the nature of charge memo, this court is not inclined to entertain the state petition, and accordingly the state petition is hereby dismissed.
I was supposed to assess this case. I was very going to like apology for that.
You want your appearance to be recorded? I will record it.
Since
But I have dictated the order. Charge memo has been issued, to go and participate.
Charge memo has been issued, but the charge memo is correlated with the absence which I have
That's
already
right.
communicated.
So you satisfy them that you were under COVID, you were suffering, whatever. We cannot quash a charge memo like this. There are altogether 11 allegations against you.
So far the charge memo is concerned, there are 3-4 more prayers with there. That should be in relation
No,
to.
please don't. I have already passed the order. If you want your appearance to be recorded, I will record it. Otherwise, I have passed the order in your absence. What do you want?
I'll let my present record in.
Counsel for the petition is present. Okay.
Article 36, WPS 367 of 2023.
Yes, petitioner.
In this case, petitioner prays for direction to the respondents to appoint the petitioner as Anganwadi Sevika, my lord, and also further prays for to cancel the appointment of respondent 9, who was appointed in place of this petitioner. My lord,
Where is your appointment letter?
Annex 1, my lord.
Who has issued the appointment letter to you?
It has been issued by the Bal Vikas Pariyojana Padadhikari, Child Welfare Officer.
This is 2004.
My lord. Subsequently, my lord, in the year 2022, my lord, fresh advertisement was issued.
So how are you concerned with
No, my
this?
lord. In pursuant to a fresh resolution by the state government stating that for appointing the Anganwadi Sevika, educational qualification must be matric. And my lord, now my lord,
You are matric?
Yes, ma'am, I am matric. But stating that the claim was rejected, stating that I do not have possessing requisite qualification, and the qualification of the selected candidate is higher than me. वो inter pass है and I am 10th pass. But at the time of initial appointment,
Where is your class 10 certificate?
वो imperial order में ही लिखा
आप
हुआ है.
अपना class 10 का certificate दिखाइए. Where is it?
I will find which affidavit. वो imperial order says, my lord, and except.
Otherwise, a person who is better qualified is certainly entitled.
But my lord, other criteria is also required for consideration, my lord.
You just say that how she is disqualified. Under which clause she is disqualified.
No, my lord, I was not considered for selection, my lord, in view of the fresh resolution.
Did you participate? Did you participate?
I participated there, but my candidature was not considered by the Gram Sabha, as because I was 10th pass, but the resolution says that the minimum qualification for having the selection of that post is the 10th pass.
It's the Gram Sabha's decision. How do we interfere with that?
As counter has been filed, so allow me to file the rejoinder.
No, you have not prayed for rejoinder at the threshold. I will not permit this. Once you start argument, no.
My lord, impugn order says, my lord, impugn order says, my lord.
Where is the impugn order? Place the impugn order.
It is in the counter affidavit.
That has been placed in the counter affidavit.
Initially, the order was not with me, my lord. I filed the petition when once.
You are just seeking a mandamus.
Yes. Respondent state has come up with one.
Where is your counter affidavit? Where is
Counter affidavit has been shown on 22nd of May, 23.
Where is it? You have mentioned that.
Alexa G, my lord, at
Page number?
86, my lord. 85. It starts from 85.
Yes. Read it, please.
Yes, ma'am. उपयुक्त विषय के संबंध में उसमें सूचित करना है कि विभागीय निर्देशानुसार दिनांक 14/3/22 को आंगनबाड़ी केंद्र आदिवासी नापित टोला
No,
केंद्र
this is not. It does not match. Annexure G. Letter number 425.
नेक्स्ट पेज मान लो 86 पे वो पूरा है.
हाँ बताइए.
उपयुक्त विषय के संबंध में सूचित करना है कि विभागीय निर्देशानुसार दिनांक 14/3/22 को आंगनबाड़ी केंद्र आदिवासी नापित टोला केंद्र संख्या 324 में सेविका चयन हेतु ग्राम सभा की गई थी, जिसमें चयन समिति सदस्यों के अतिरिक्त 77 ग्रामीणों की उपस्थिति में ग्राम सभा की कार्रवाई पूर्ण की गई. Column number 5 is the selected candidates, my lord.
Yes.
Poonam Kumari. And my lord, in the next my lord, they have intimating that. सूचित करते हुए कहना है कि उक्त आंगनबाड़ी केंद्र अनुसूचित जनजाति बाहुल्य से है एवं श्रीमती पूनम कुमारी पति अजय प्रसाद मुर्मू अधिकतम योग्यताधारी एवं जाति वर्ग बाहुल्य से हैं, जिसका चयन समिति सदस्यों एवं ग्रामीणों की पूर्ण सहमति से किया गया है. शिकायतकर्ता कुसुम देवी पति श्री गुलाब चंद मांझी उक्त केंद्र में सहायिका है, सहायिका के पद पर कार्यरत है. इनकी शैक्षणिक योग्यता मैट्रिक है. योग्यता कम होने के कारण इनका चयन पर कोई विचार नहीं किया गया. But the other
WPS number 367 of 2023, this writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that by virtue of a circular issued by that the petitioner was working as Anganwadi
Sevika.
Sahika,
sorry.
Anganwadi Sahika,
Sahika.
Since 2004, which is apparent from memo number 976 dated 13/12/2004 as contained in Annexure 1. However, by virtue of the circular issued by the state government, a fresh selection process was started, and ultimately the petitioner was not selected, although the petitioner was duly qualified, and consequently the present petition has been filed. The learned counsel for the respondents has submitted that a counter affidavit has been filed in the present case, annexing memo number, annexing letter number 411 dated 9/11/2024. Is it this letter number?
22.
No. Annexing letter number 425 dated 10/11/2022 and the decision in connection with the non-selection of the petitioner, clearly indicating that the candidate who has been selected was having better qualification as compared to the petitioner, and this was for selection for Anganwadi Sevika. And the petitioner is already working as Anganwadi Sahika. The selection process was for the purposes of Anganwadi Sevika. Considering the reasons cited by the respondents in the counter affidavit, Annexure G, this court finds no merit in this petition, which is accordingly dismissed.
Item 37, WPS 571 of 2023.
Yes, petitioner.
The petitioner was appointed as a Anganwadi Sevika. By Annexure 3, an appointment letter is there. Madam produces page number 33 of my petition. This is order dated 9/9/20 passed by Bal Vikas Pariyojana Padadikari.
Then what happened?
It might not just come prior to
This
just
is,
this.
you were Anganwadi Sevika.
Yes. Anganwadi Sevika in this प्रखंड that is Mahesh Khanda के लिए किया जाता है.
That's right.
अब just इसके पीछे my note page 31 में kindly be seen. This is the minutes of meeting of the arms hour. Altogether 5 candidates appeared. Out of 5, 3 were ousted because they were not having the requisite qualification. 2 were there. Now one is this petitioner and the other is Lalita Devi, who is the respondent number 7 here, private respondent. Now प्रस्ताव संख्या 6 में kindly be seen. 5 and 6 दो प्रस्ताव बस एक पैराग्राफ पढ़ेंगे. प्रस्ताव संख्या 5 क्रमांक 2 की आवेदिका ललिता देवी पति नरेंद्र कुंवर शैक्षणिक योग्यता मैट्रिक उत्तीर्ण जन्म तिथि इतना तथा ये पिछड़ी जाति के अंतर्गत आती है. इनका मैट्रिक की प्रतिशत 48%. दिस इज अबाउट रिस्पोंडेंट नंबर 7. प्रस्ताव संख्या 6 क्रमांक 3 में आवेदिका अयोध्या कुमारी पति मुकेश कुंवर शैक्षणिक योग्यता मैट्रिक जन्म इतना है तथा पोषण काल तथा बहुल वर्ग से आती है. मैट्रिक का परिणाम 51% है. So she is having more requisite, more marks than the respondent number 7.
What is the bahul work over here?
Means the majority of
Majority is from which community?
To which the petitioner belongs. इसीलिए इसमें लिखा हुआ है कि ये बहुल्य इससे आती है.
और ये वाला ये रेस्पॉन्ड नंबर 6
वो उनके बारे में कि पिछड़ी जाति के अंतर्गत आती है.
बहुल वर्ग किसका है? पिछड़ी जाति का है, एसटी का है, एससी का है, किसका है? Anganwadi Sevika has to be appointed from the majority community.
Majority committee.
Which is the community, is the majority community here?
On all the aspects, these two are on the same footing, my lord. I am not disputing that. But only marks I wanted to show, she is having more marks than this respondent number 7.
Is there any?
Yes, the rule.
Rule says that it is a person having more marks will be given priority.
Page 24, madam. Page 24 is the circular rule by which the appointment of Anganwadi Sevika is dated, madam. Clause K, 7 का K. आंगनबाड़ी सेविका न्यूनतम शैक्षणिक योग्यता प्रवेशिका उत्तर सिर्फ अनुसूचित जाति जनजाति के सेवक के लिए न्यूनतम योग्यता प्रवेशिका उत्तीर्ण सुयोग श्रेणी की अधिकतम शैक्षणिक योग्यता वाले उम्मीदवार को प्राथमिकता दी जाएगी. So this line I am happy with.
अधिकतम शैक्षणिक योग्यता does not mean more marks. It could be inter. It could be graduation.
But since both are matriculate, therefore my condition would be a person
your educational qualification is
equal. Yes.
So, what is
now,
your case?
Now, after this, what happened? If my lord closes in page 32, there it has been mentioned कि सर्वसम्मति से मेरा चयन किया जा रहा है. This is also important in Am Sabha, my lord. Page 32, last paragraph.
So you were selected with
the consent of the Am Sabha, and my appointment letter was issued by the competent authority, that is Bal Vikas Pariyojana Padadhikari, Dumka. Thereafter, this candidate, respondent number 7, she filed a complaint before the deputy commissioner. She filed a case. Now that case, my lord, the annexure is annexure 8, page 38 onwards.
There is a remedy of appeal against this. You have a remedy of appeal as per the scheme only.
Against deputy commissioner order.
Yes. Page number 5, internal page 5, page number 27.
Page number 27. निदेशक संघ सुविधा और सहयोग चरण में प्रसंग में अपील विभागीय सचिव के पास देना by lord will dispose it of.
You withdraw it. I will permit you to avail remedy. After some argument, the counsel for the parties are present. This petition has been filed for the following relief. Should I record that you have pointed out this appeal?
Lordship, in this matter, even order has been passed to hold a fresh selection.
He is agreed by an order.
My candidature has been rejected.
Yes, Lordship.
So I am agreed.
That has been rejected because it has been done in contravention of rule and.
He has a remedy of appeal. You are challenging that order, no?
Yes, I have challenged. Yes. Both order, the deputy commissioner and subsequently order of SDPO also. That is under challenge.
During the course of argument, it transpired that as per the scheme applicable for induction of Anganwadi Sevika and Sahika, there is a provision of appeal in terms of clause 17 thereof. This provision being pointed out, the learned counsel for the petitioner seeks permission to withdraw this petition in order to avail the alternative remedy as mentioned in clause 17. You have any objection to that?
No.
The learned counsel for the respondents has no serious objection to the prayer for withdrawal. Considering the submission, this petition is permitted to be withdrawn. Liberty is reserved with the petitioner to avail the alternative remedy as may be permissible under law.
Sign कर दीजिए सर. Sign कर. Item 38, WPS 1112 of 2023.
This case is opinion of ground respondent number 11 and I got IA for acceptance.
What is your?
Plus my twofold prayer. To conduct an inquiry by the Caste Scrutiny Committee.
You have a Caste Scrutiny Committee. Go there.
Because I have filed application before the Caste Scrutiny Committee.
Okay. Where is your application?
Plus the Annexure 7, page 34.
When did you file it?
I sent through speed post.
When?
I'm giving the date.
31/2023.
31.
This can last page I have it.
We can't even accept deemed service. You have filed it on 22/2/23.
Yes.
Then, what kind of direction are you seeking from this court? You have approached, they will consider.
Plus, they have not taken cognizance of it till.
Therefore, I am saying that 31/23, you send it through post,
Yes.
and you file the writ petition on 22/2/23. You didn't even wait for 1 month.
Plus after one, yes. Plus.
So they will only act after 1 month because
Now
they will be
let's-
deemed service only after 1 month.
Plus now 24 minutes. Till that must not.
We do not know.
Plus,
This writ petition has been filed in a haste. And this court does not have any jurisdiction to enter into caste status.
the caste scrutiny committee is the only to inquire the caste certificate. The department has given clean sheet to the.
We are not concerned. They will do it whatever they are. This
Yes,
is
but
the only relief
this
you
is
are
the my
seeking.
prayer. Let it be do by the caste scrutiny committee.
Your prayer is only with regard to scrutinizing his caste.
Yes, ma'am. And second for prayer to cancel the appointment of and also insert appropriate legal procedure as they are taking appointment on to public office.
So everything is sequel of caste
Yes,
certificate.
caste.
Yes, you have a respondent number 11.
Respondent number 11.
If he files an application before caste scrutiny committee questioning your status, then everything will ultimately boil down whatever caste scrutiny committee decides.
Yes, my lord, but my submission before my lord is that he is no locus, my lord. How he is aggrieved? And how
See, anybody can be aggrieved regarding status.
my lord, in applicant.
No, anybody who is in public employment, if he obtains an employment by fraudulent method or illegal method or irregular method,
my lord, he has not moved before this honorable under writ of quo warranto, my lord. Cable order and direction, my lord, and I am relying on the order passed by the Honorable Apex Court as well as the order passed by the coordinate bench of this Honorable Court, my lord, which says that unless and until there is a locus and the person.
the caste status of a person cannot be questioned.
Yes, my lord. This is the order passed by the Honorable Apex Court, my lord.
That in order to challenge the caste status of a person, there has to be a locus. PIL, it is not a PIL. This is not a PIL. He is questioning your caste status, he has filed an application. If you have any objection regarding his petition, his locus, whatever, you take your plea, whatever is there. But no notice has been issued and this writ petition itself is a premature one. Because on the day he has filed it, even 30 days had not expired from the date of filing of his representation before the caste scrutiny committee. Who is representing caste scrutiny committee over here? Where is the... You have not even made this respond number 3. Are you representing respond number 3, madam?
Yes, Your Lordship. Number 7.
Department of Procedural Tribes.
Learned counsel for the parties are present. This writ petition has been filed for the following relief. The counsel for the petitioner submits that a petition has been filed before the caste scrutiny committee by letter issued through post on 30/1/2023, but no steps have been taken. The private respondent has entered appearance by filing wakalatnama and an interlocutory application has been filed with a prayer to accept his wakalat. Being IA number
9349 of 23.
9349 of 2023. The learned counsel has submitted that the petitioner has no locus to question his caste. He has also submitted that the private respondent is in public employment, right?
Yes.
He is in public employment, and the petition has been filed by immediately after filing the representation, and the petitioner did not even wait for issuance of any notice by Caste Scrutiny Committee and has simply rushed to this court. The Learned Counsel for the state has submitted that the status regarding caste is the status regarding caste is the exclusive jurisdiction of Caste Scrutiny Committee in view of the judgment passed by the Honorable Supreme Court in the case of Madhuri Patil. Reported in
1994.
1994,
6 SCC
Volume 6
240.
SCC 241. Kumari Madhuri Patil, right? After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that all the prayers made in this writ petition are related to the caste status of the private respondent. This court finds that the petitioner claims to have filed his representation before the Caste Scrutiny Committee on 31/2023 and has immediately rushed before this court on 22/2/2023. This court is in such circumstances, this court is not inclined to issue any mandamus. However, it is for the petitioner to pursue his application said to have been filed before the Caste Scrutiny Committee. And there is no reason indicated, and there can be no reason for the Caste Scrutiny Committee not to act in accordance with law. Right?
Yes.
That should be sufficient.
And in the guideline given by the Honorable
in terms of the applicable circulars and the guidelines already issued by the Honorable Supreme Court. This writ petition is accordingly disposed of.
Unless any time frame.
Nothing. You have filed a premature writ petition. You did not even wait for 1 month. IA for entrance of appearance is allowed.
Item 39, WPS 1145 of 2023.
Yes, petitioner.
My lord, this is compassionate department matter, my lord. The petition is filed for questioning the order dated 8/7/22 by the respondent number 4, annexure 4. Petitioner number 1's husband, Hatu Manji, died on dated 4/3/2016 during the period of his service, my lord. And the petitioner number 1.
Who is the petitioner?
Petitioner number 1, Panpati
Is the wife.
Wife. And
Petitioner number 2 is the daughter.
Is the daughter.
Married daughter.
Married daughter, madam. But
And dependent on her husband.
No, her husband is nothing labor, my lord, and she is only the child of their parents. No brother, and only she is.
The question of compassionate appointment will come only if she is a dependent on the deceased employee, irrespective of whether she is married or unmarried.
My lord, petitioner number 1.
What is the reason for rejection?
Reason that she.
You read the rejection.
Regarding a reconsideration of employment claim of your daughter Smriti Parvati Devi in compliance with the direction passed by Honorable High Court Jharkhand by order dated 13/9/2018 in WPS 4598 of 2018. Madam, this is in relation to your writ petition WPS 4598 of 2018 filed for challenging the rejection of your married daughter Smriti Parvati Devi appointed on the compassionate ground under para 9.33 of NCWA 6, in which the Honorable High Court by order dated 13/9/2018 directed to respondent number 4 IFO Executive Officer Burkunda to re-examine petitioner's married daughter Parvati Devi claim in the light of reissue rendered in the case of Hemanti Devi in LPA number 196/2017. All other eligibility conditions as prescribed under the clause 930 of NCWA 6. That pursuant to the compliance to the order directions dated 13/9/2018 passed by the Honorable High Court Jharkhand in WPS 4598 of 2018, it was necessary to ascertain as to whether Srimati Parvati Devi was the dependent on the income of the deceased and staying with the deceased. A committee was accordingly constituted by the office order dated 19/4/2022 to ascertain the dependency of your daughters Parvati Devi on the father, late Fattu Manjhi, income at time of his death. A copy of his order dated 19/2022 is enclosed at Annex A. That during the inquiry, your daughter Smriti Parvati Devi's son-in-law Sri Mitresh Munda were given employment opportunity to produce evidence regarding their dependency on your deceased husband, late Fattu Manjhi, ex-employee income at the time of his death.
Madam, you file your contract. What is the material to show that they were not dependent?
Yes, sir, you should.
You produce the record. They are not supposed to leave negative evidence, right? You have to show from positive evidence that she was not dependent.
My lord, order is given by petitioner 4598 of petitioner number 1 already filed in Honorable High Court. This is the favor of my petitioner.
There is a direction to give you compassionate appointment.
Attend.
There is a direction. Then you file contempt.
In Annex 2, my lord, Annex 2.
Only for consideration of it.
Only for consideration, my lord. और ये जानने की बात है उसका एक ही को वही बच्ची है और उसका
counsel for the parties are
उसका हस्बैंड एक लेबर है
counsel for the petitioner
भूखमरी के कगार पे है, गरीब है वो लोग एकदम.
Counsel for the petitioner submits that the petitioner number 2 is the daughter of the deceased, is the only daughter of the deceased. He has no male child. The deceased had no male child. And the petitioner number 1 is the wife of the deceased. He submits that the impugned order. The petitioner number 2 is also a married daughter. He submits that the impugned order has been passed pursuant to order passed by this court in WPS number 4598 of 2018, dated 13/9/2018, and the matter was directed to be re-examined. The learned counsel submits that there is no material on record to suggest that the petitioner was dependent on her husband and not on her deceased father. The learned counsel has further submitted that one of the reasons for passing the impugned order is that the petitioner, that during inquiry it could not be proved that the petitioner was dependent on her father, as no such document was produced. The learned counsel submits that it was for the respondents to. Nay, the learned counsel for the petitioner submits that the petitioners could only say that they were dependent on the deceased father. Any contrary material was to be brought on record by the respondents. At this, counsel for the respondents is directed to seek instruction and file a counter affidavit by 14th of March, rejoinder by 19th March, post on 20th March under the heading for final disposal. The respondent shall produce the records before this court for perusal.
Item 40, WPS 4757 of 123.
Petitioner.
Payment of the arrear of salary of
From date of joining?
Yes.
Very good. You have been working without salary since 1988.
Yes, but exactly that is it. We have filed the reparation.
So why do you suddenly need the salary in 2023?
Because when we have filed the reparation, then the department has broke up and made a return loss by an Excel 3 loss. Copy in Excel 3 for that is page 56.
This is your page 53.
Yes, passed by to the secretary of to the DSC Sahib. Then by an Excel 4 loss we make the reparation before the deputy commissioner.
You just tell us.
Stated in detail all the
Just a
facts.
moment. Page number 53. Let me just see page
Page
number
56.
How do you have your cause of action?
Hereafter come to the page 57, my reparation.
Page 53.
Page 56 is the letter.
No, you just
by
tell
the
us.
department.
Which is the letter? Your page number does not tally. You tell us.
Can you see page in Excel 3?
An extra?
In Excel
3.
Memo number 2303 of 3/12/21.
Page, that memo number is not there. So where do I get this
Annexure 3
memo?
is relying on Annexure 3.
In Excel 3 I will.
दिखाइए उनको जब दिखाइए कहाँ है बताइए कहाँ पर है आपका निकालिए डॉक्यूमेंट
It is after the tag of this.
I have to get placed by an Excel 2.
Yes, read it. Yes.
And thereafter, when the department has woke up and consider my application.
You read it. You read this document because this is a cause of action.
विषय श्री सकलदेव हावड़ा जिला सहायक बैंक के आवेदन संबंध में उपयुक्त विषय संबंध में कहना है सकलदेव हावड़ा ग्राम पहाड़पुर और बड़ा दुर्गापुर के पहाड़ अंचल तालझाड़ जिला सहायक बैंक द्वारा लंबित वेतन के भुगतान एवं विद्यालय में पुनः पदस्थापित करने के अनुरोध हेतु
पुनः पदस्थापित का क्या मतलब है?
Because they have not accepted my join.
So when did you give that joining which they did not accept?
No, we have given the joining pursuant to the district establishment committee. I was appointed on 1888.
1888.
We have given the
And when did you
joining
give
on
the joining?
Yes,
When did you
188.
21/188. You
Thereafter,
gave the joining.
That has been approved, yes, sir.
Okay, this
Before
just a
the
moment.
Primary school, Bakura, my
Please
school.
hold on.
Yes. They have approved
You
my joining.
please hold on. You say on 21/188 you gave your joining and this joining was approved.
Approved.
When?
On 4888
4/888.
by the DSC Sahib.
DSC Chennai.
Thereafter, when no payment has been made.
Just a moment. Then where was the occasion for you to again file an application for acceptance of your joining?
That's because in the October 21, one circular was issued by the department that the person who was absent from the school.
So you were absent from the school. Did you work during this period?
Yes, we have made the request, we have worked in the school.
Where have you stated that during the period from 1988 till 2021 you have been working? Show me one statement that you have been discharging your duty.
Paragraph 9 or 6.
Yes. Yes, you just read.
First paragraph 7 we have stated about my serial number.
No, what is it? You read para 7.
Paragraph 7 that the prisoner has after examining the exemption certificate of the prisoner. Respondent 5 by memo number certain dated 4888 grant permission for payment of salary. Love other similarly civil person in which Mr. place at around 40. By order the headmaster was said his school Mr. had opened up the account. But is the misbehavior committed by the headmaster resulted in the monthly report. Respondent 5. Mr. was deprived from a monthly salary and without any information, without any show cause. Mr. was showed as absent. And such
This happened in 88. This happened in 88.
Yes.
What were you doing since?
Thereafter, we have made the representation on
When representation?
that is lecture 1 is from the 9/6/88. That is lecture 1 so we can represent there.
And where is your statement that you have worked continuously? These two things you just tell us.
This paragraph where the prisoner has repeatedly stated the matter from 88 onwards. The payment of salary as well as rejoining in the school.
Rejoining
When
means
no
what?
action has been taken.
What is rejoining? We don't understand. What is rejoining?
Paragraph 9 comes also.
What is the meaning of rejoining the school?
Because the school management has that the attitude of the headmaster that the prisoner has put the separate attendance. Then that is the paragraph 9 also. Why the department has woke up and come to the exam. Then the prisoner come to know about the survey issue as education department, which has said there are good teachers who have been suspended for more than 2 years or are absent due to any reason. Then those teachers have been directed to be joined in the schools, and if they are bound in involvement of any serious offence, then this should be sent to the government. Then the prisoner had submitted the request to the respondent number 2 by split for 25/21. Then lecture 3 has come.
No.
Thereafter lecture 5. Can I say lecture 5 also? What they were saying? See again the letter.
Where is your statement in your repetition that you have been continuously discharging your duty in the school? You show it from the writ petition. Don't show it from the annexures. Show it from the writ petition that you have been continuously discharging your duty since 1988 and no payment was made.
No, by then my matter has been referred to the.
I just want to know you are breaking up an issue way back of the year 1988. You tell us. There may be so many people, so many advocates in the High Court who might not have even been born in 1988.
No,
Isn't it? Yes. You want a salary from 1988 in the year 2023. Is there any statement made by him that he has been working?
No.
Okay. WPS number?
Long delay.
WPS number 4075 of 2017. This writ petition has been filed for the following relief.
What is it?
We will see.
I guess 5 is there.
We will see.
They have again referred my matter.
They will keep on referring it.
No,
But
no.
we are not going to ask them to give your salary for 1988. If they have referred it, you pursue your remedy. We do not know anything.
No,
But
we
we
have
are not.
pursued the remedy, but they have not taken any decision.
So, I am not inclined to give any mandamus for them to take any decision.
Take any action also.
No,
And if for moment I see in lecture 6.
I have seen.
Lecture 6 is last by the person. We say all the things, page 61.
Page
Page 61. After lecture 5,
61.
Page
61 is your representation.
It's last impression before the DSC part. Who had to require to take that.
That's
बापराम साहब के पर स्थापित हूँ यह कि महिला स्थापना समिति की बैठक 22/12/57 सूची के आधार पर अनुमति प्रत्येक सूची के क्रमांक छोड़ मैं नाम के सामने अंकित विद्यालय में आइए उपस्थिति वेतनमान 22 रूप से प्रदत्त किया गया है। दिनांक 1/88 को अंकित नियुक्ति पद के आधार पर मैंने अपना मेडिकल दिनांक 21/88 को पटकन शिक्षा पर को समय अनुदान दिया। वह नियमित रूप से कार्यरत रहे। एक सस्ती जिला शिक्षा अधीक्षक साहिब।
You see, we are not inclined to grant any relief to you.
But all the things that
On
you
belated
mentioned,
claim,
why
we
I
don't-
have not performed the duty, what is the reason they have not made the plan?
WPS number.
Then we
You
have
want
also
to,
affected large part.
you want an order or you want to pursue your remedy?
I want to pursue my remedy.
Then you withdraw.
On the basis of my last impression, they should take a decision.
No, I am not going to give you any mandates for a relief of the year 1988. WPS number 4757 of 2022, district petition has been filed for the following relief. The learned counsel for the petitioner submits that this court is the learned counsel for the petitioner has submitted that as per the decision of district establishment committee, the petitioner was appointed to the post of assistant teacher, and as per the merit list, the name of the petitioner was at serial number 114 under IA untrained, and thereafter the petitioner was issued appointment letter dated 1/1/1988, and after submitting medical fitness, he submitted his joining on 21/1/1988 before the Block Education Extension Officer Maheshpur 1, and he was posted at Primary School Pakur under Maheshpur Block 1. He has further stated that the respondent number 5 by stated in para 7 that respondent number 5 by memo dated 4/8/1988 granted permission for payment of salary and other benefits, but due to misbehavior committed by the headmaster, the monthly report regarding payment of salary did not include the name of the petitioner, and consequently the petitioner was deprived of his salary without any information and without any show cause, and he was shown absent. In such circumstances, the petitioner was putting his attendance in a register as per the instruction of the Block Extension Officer Maheshpur and performed his duty. The learned counsel for the petitioner submits that the petitioner has been representing right from 1988 for payment of his salary as well as for rejoining in the school. The learned counsel submits that in the year Paragraph 9. A circular was issued in the year 2021 by the Education Department, which stated that those teachers who have been suspended for more than 2 years or are absent due to any reason were directed to join in their school, and if the teachers are found involved in any serious offences, then the list should be sent, and consequently the petitioner submitted a representation dated 25/8/2022 narrating the entire facts and prayed for payment of salary and rejoining as per the circular of the Education Department dated 12/9/2021. The learned counsel submits that the respondents have issued letters to take a decision, and ultimately a representation was filed by the petitioner lastly through speed post on 27/8/2022 before the District Superintendent of Education Pakur, but no decision has been taken. The learned counsel for the respondents has opposed the prayer and has submitted that the writ petition is a belated matter, and the petitioner has himself stated that he was never paid salary, and the learned counsel has relied upon a judgment passed by this court in WPS number 4075 of 2017 dated 28/8/2018,
Paragraph 7.
para 7, to submit that such belated claim be not entertained in this writ petition. After hearing the learned counsel for the parties and going through the records of this case, it appears that the petitioner claims to have joined the school on 21/1/1988, but at the same time, the petitioner was never paid any salary, and rather, as per paragraph 7 of the writ petition, the monthly report from the school did not include the name of the petitioner. It is a case of the petitioner that the petitioner was made to make attendance in the separate register, but admittedly the petitioner was never paid any salary. The petitioner claims to have filed representation as back as in the year 1988. Considering the totality of facts and circumstances of this case, and particularly the fact that the name of the petitioner never reflected in the monthly report submitted by the school, and the petitioner was never paid any salary since the year 1988, the petitioner did not approach this court earlier and has filed the petition only on 18/8/2023. The claim of the petitioner is especially a belated claim, and in such circumstances, this court is not inclined to exercise power under Article 226 of the Constitution of India for issuance of any relief as prayed for by the petitioner in this petition, which is accordingly dismissed.
Item 41, WPS 5762 of 2023.
Some latest development subject to lots of consideration. ये देखिए
Transfer order.
Transfer matter. Now subsequently they have issued this letter. So the transfer order is under challenge, that is intact as on date also. For 2 years she has been relieved to join some other department as a HOD 13/10/23 for 2 years, and again she will come back to this annexure. So transfer order is issued, which is a punitive in nature.
How do you say punitive?
Yes, Lordship. Because
this transfer order is still surviving.
Is still surviving.
So what is this order?
This for the time being, I have after this impugn order, annexure 8, this subsequent development they have made for the 2 years from that transfer place in terms of annexure 8. I have been made HOD in the university for the period of 2 years. After the lapse of 2 years, again I will come back to the.
We do not know what is going to happen after 2 years.
This writ has become infructuous.
Yes.
In view of the fact that the petitioner has now been posted in the postgraduate department of English as the head of the department.
In?
Postgraduate department of English, my lord. In the university, postgraduate department of this English, he has been posted as head department of English.
WPS number 57. WPS number 5762.
इंग्लिश नहीं है, पॉलिटिकल साइंस उसमें देखिए ना दिए हम आपको सेकंड नंबर नाम
Dr. Rashmi Kumari.
Yes, Lord, sir.
Incharge head.
Incharge head.
The learned counsel for the parties are present. This petition has been filed for the following relief. Memo dated 13/10/2003.
Impugn order to 8 है actually.
A memo dated 13/10/23 has been produced before this court, indicating that the petitioner has now been posted in PG Department of Political Science, Konhan University, Chaibasa, as in charge head. By referring to this memo, the learned counsel for the petitioner has submitted, the learned counsel for the respondents has submitted that the present writ petition has become infructuous on account of subsequent development. Upon this, counsel for the petitioner has submitted that the said posting is only for a period of 2 years. Considering the aforesaid facts and circumstances and the fact that there is a subsequent development that the petitioner has now been posted as PG as in charge
head in
PG Department of Political Science, Konhan University, Chaibasa. This court is not inclined to proceed any further. This court is not, this writ petition has become infructuous for all practical purposes. Accordingly, this writ petition is dismissed as such.
Subject to lordship consider as lordship said. Take.
Continue.
From dead list for orders petition Act 1, WPS 1869 of 2023.
Your Ladyship, praying for 4 weeks time.
Why 4 weeks time do you need?
We have to remove the defects. That's why we are seeking for sample request to praying for.
You have to file the court fees primarily. What do you mean 4 weeks time?
Lordship is sample request.
No, we will not give you so long time. You
Lordship
don't.
is
You
sample
have been
request.
praying for time before the Registrar General. 2 weeks on 1/5/23. Thereafter 19/12/23 also you paid for prayed for 2 weeks, and now this matter has been listed in 2024. You still need time.
Lordship, last opportunity may be given.
I will give you last opportunity. Preemptory order will be passed, but not 4 weeks. 4 weeks is too long.
Lordship is under humble request for this time will be given.
I will impose some cost on you, then I will give you 4 weeks time. How much cost are you ready to pay? 21st March you remove the debate. By 21st March. Learned counsel for the parties are present. उतना भी लिखने का जरूरत नहीं. Time till 21st March is granted to the petitioners to remove the surviving defects preemptory. If the defects are removed within the stipulated time, pose this case on 8th of April under appropriate. This order is for all the cases. We will draw one case, one order for all the cases, right? There is one petition 23 and 24 for ignoring the defect. There are certain petitions for ignoring the defect.
Serial number 21.
Okay,
I want to withdraw this case.
Serial number 21.
Yes, ma'am.
The learned counsel for the petitioner, Mr. Arshad Hussain, seeks permission to withdraw this writ petition. Permission is accorded. This writ petition is dismissed as withdrawn. Serial number 21. Sign kar lijiye.
Relief sought for has been granted.
That's right. Nothing is required to be stated. Anybody?
Serial number 23, madam.
You want to
In
withdraw?
course of the day, madam. What you want page is to get 5 type copies. In course of the day, make permission be granted, madam.
To remove the defect?
To remove the defect.
I have given you the time. You remove the defect.
Today itself I am going, madam, because it is ready, madam. Permission may be.
You have filed an IA for ignoring the defect.
That is not required. It has become infructuous.
Just a
Forever
moment.
past.
23 में एक चीज लिखिएगा. Serial number 23 में IA number 7356 of 2023. Counsel for the petition submits that that he does not want to press the interlocutory application. The interlocutory application is dismissed as not pressed. बाकी नहीं pressed, same order.
Well, you want defect, I give defect.
You do the, you remove the defect.
2 days.
I've given you the dates.
In course of time, madam.
I've given you the dates.
So because
What is
my
serial
lord,
number 20?
some similarly situated cases, are pending, my lord, before my lord in court number 8, my lord. So therefore I was saying, my lord.
We do not know.
Only in course of the day, my lord. Only one order, my lord, in course of the day.
So you remove it, it will come on the date. I have already given the date. On 8th of April it will come. You can remove it at your leisure. No, we are in defective petitions. We are not going to pass separate orders.
No, separate order may not be passed. Only in course of the day, my prayer may be noted.
You can do it still now.
But no order may pass regarding date, my lord.
No, we have to fix a date in
No, my
every
lord,
case.
because my lord, I have to mention.
You cannot dictate the order like
no,
this.
My prayer may be considered, my lord.
What prayer?
My prayer is, my lord, that similarly situated implies I prefer the petition and the date is fixed, my lord.
What is the date fixed?
Yes.
What is the date fixed?
29th of this February, my lord.
29th February.
February.
Day after tomorrow.
Day after tomorrow. Therefore, I have to make prayer in the court.
Which court will you make the prayer?
I will in the coordinate bench.
No, you cannot make a prayer of this particular petition in coordinate bench.
Because, my lord, this is also 2023 matter, my lord.
You cannot make a prayer for listing of this case in coordinate bench, isn't it?
But, my lord, I will pray, my lord, because some similarly situated cases are pending, my lord. Which karke analogous cases are there, my lord. Therefore, only my prayer was, date may not be fixed. May it be, my lord, graduate counsel is permitted for filing in course of the day, removing the defaults in course of the day. Because only one page is to be
Then
filed.
it will be a preemptory order again.
Yes, my lord. Permission to be granted.
Serial number 23 में और लिखिए. The learned counsel for the petitioner submits that he be permitted to praise for and is allowed to remove the surviving defect during the course of the day, preemptory.
So permission.
That's it?
Yes, permission.
Page number 23. Serial number 23. Office to check if the defects are removed. Post on. You want 29?
29.
20. Today is 26. 29th, we have a different board on 29th.
Date may not be mentioned.
That has to be mentioned, Mr. Counsel. It can't be like this.
29 may be done.
Preemptory time I have already given.
But date may not be fixed. Because so preemptory time is for today. That is for removing the defect only.
No, we can't do it like this. If the defects are removed, post tomorrow. चेक करा दीजिए. करिए अभी तुरंत फाइल करिए. अभी चेक करा के कल इसको लगा.
अभी तुरंत
करिए तुरंत. We are taking it on record. Right. The filing which is placed on board is taken on record. कल रहेगा. नहीं तो DFD हो जाएगा तो आप जानिए. We do not know anything. Next.
Serial number 26. We have filed the tied copy.
So you have to remove the defects, whatever it is. There is one more prayer, page serial number 24.
I am appealing for serial 24. My lord, we have filed an IA in this matter, my lord, for ignoring a defect.
What is the defect?
My lord,
Serial
the
number 24.
included order, my lords, which has been served by the DC of DM Hazaribagh, we have been served the relevant copy only, and we would rely on that only, my lords. For ignoring that part, my lords, we have filed the IA in this matter. Yeah, that is annexure 9.
Annexure 9.
My lords.
Which is that part you are relying upon?
Annexure 9 starts at page 44. At page 45, at serial 34, mentioning regarding me has been made, my lords. Annexure 9, page 44.
Where is your decision?
My lords, on page 45 at serial number 34, we have earlier preferred a writ, my lords. The mentioning regarding that has been made. Serial 34 at the lower portion, my lords. That the same has been considered and passed in employment is not to be done.
देखिए आइए नंबर 9208 of 23 in WPS number 4424 of 2023, the learned counsel for the petitioner submits that the defect number 6 be ignored in as much as the relevant portion so far as it concerns the petitioner has been annexed as annexation 9, which would be sufficient for the purposes of the decision of the present case. Considering the submissions, IA is allowed, and any other defect?
Notes for defect number 5, 7 and 8, we have already filed a supplementary affidavit.
So far as the other defects are concerned, he submits that he has already filed a supplementary affidavit. Office to check, pose this case under appropriate heading on list.
Much obliged. Next thing. Any next time?
Sorry?
Any next thing?
Any? Next Tuesday.
Much obliged.
That's all. Done. Is there any petition for ignoring defect? Serial number 27. This is for
27 हो गया वो orders में था.
अच्छा वो एक close हो गया. All done? चलो. Rest same orders. We have two different orders in only two cases. One is serial number 23 and other is serial number 24. In all other cases, it's the same.
Okay, spelling item 42, the rupees 5782 of 2023.
Yes, petitioner.
Lordship, my prayer is twofold. One is for payment of MACP, and the second is a special prayer, Your Lordship. It relates to a circular of the Bihar government, wherein it was said that if the petitioner undergoes vasectomy, Your Lordship, he will be given one pay increment. So these are the two prayers, Your Lordship.
So when did you undergo that operation?
Back in 2002, Your Lordship.
2002.
Back in 2002, and I have
That circular was still operative?
Yes, Your Lordship.
You have filed your representation?
Yes, Your
Lordship. Before whom have you filed?
Lordship, just before my retirement, I have represented before Special Land Acquisition Officer, Your Lordship. The Special Land Acquisition Officer before my retirement has also written to the Secretary of Minor Irrigation Department.
Where is that?
Your Lordship, Annexure 2 maybe.
Annexure 2 page number?
Running page number 15, Your Lordship.
The matter is now pending before the Secretary.
Lordship, the Secretary.
Okay. Learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner has attained the age of superannuation on 31/7/2023, but two reliefs are still pending consideration. The first one is relating to grant of modified assured career progression scheme within bracket MACP. The petitioner was given first benefit under ACP with effect from 11/11/2001 and MACP with effect from 11/11/2019, but third MACP has not been granted.
2009, Your Lordship. 2009, Your Lordship. The second MACP.
Just second MACP on
11/11/2009,
but third benefit under MACP has not been granted. The petitioner completed 30 years of service. She has also submitted that the petitioner had undertaken the required surgery in terms of the rule, namely Bihar government servant within brackets special provision relating to family planning bracket close rules 1977. When did you undertake the operation?
Your Lordship, my cause arose in 2002, Your Lordship.
In the year 2002. Where is it mentioned?
Your Lordship, paragraph number 11 of the pleadings.
In the year 2002. But the benefit under the said rule has not been granted. She submits that the petitioner has represented before the authorities and by letter number 16 dated 15/5/2023, the concerned special land acquisition officer at Chaibasa has referred the claim of the petitioner for approval to the Undersecretary,
No, Undersecretary.
Water Resources Department, Jharkhand Ranchi, and therefore, but no decision having been taken, the present petition has been filed. The learned counsel for the respondents has submitted that though no counter affidavit has been filed in the present case, but considering the material, the respondent number, you have made the secretary. Where is undersecretary? You have not made.
The secretary is respondent number 2, Your Lordship. Undersecretary has yet not been made the party, Your Lordship. Your Lordship, the undersecretary's letter was given by the special land acquisition officer.
You have not made him party.
The special land acquisition officer is respondent number 3. I have represented before him. He has forwarded the letter to the undersecretary.
So he is not a party.
Lordship,
The learned counsel submits that the undersecretary of the department to whom the matter has been forwarded can look into the grievance of the petitioner, and if required, the matter can be also looked into by respondent number 2. After hearing the learned counsel for the parties and considering the nature of relief as prayed for by the petitioner, this court finds that no adverse order regarding the claim of the petitioner has been placed on record, and it appears that the claim of the petitioner has been forwarded to the Undersecretary of Water Resources Department by the Special Land Acquisition Officer by letter number 16 dated 15/5/2023, and the final outcome of the same has not been communicated to the petitioner. Accordingly, this petition is disposed of, enabling the petitioner to approach the respondent number 2 by filing a representation along with a copy of the records. The respondent number 2 shall consider the grievance of the petitioner, either himself or refer the matter to the Undersecretary for appropriate orders. The authority shall pass a reasoned order in connection with the claim of the petitioner and communicate the same to the petitioner through speed post. This court has not gone into the merit of the claim of the petitioner. It is for the respondents to consider the claim in accordance with applicable guidelines.
Lordship, just a time frame may be given, Your Lordship.
Within 2 months.
Item 43.
You have to produce your the counsel for the petitioner. The petitioner shall also produce the adequate proof regarding the fact that the required steps were taken under the rule of 1977. Along with the representation, you will have to annex that.
Request 5789 of 123.
Yes, petitioner.
There is an old RBA and the counter of the university has not been filed. During the pendency of this writ application, IA number 1688 of 24 has been filed, by which the respondent come out with the letter dated 8/9/23. They saying that the teachers does not mean reader, which is against the section 2 of the university law.
8/9/23 was issued prior to filing of the writ.
No, Your Lordship. That is annexure 8 of the writ application, Your Lordship. Annexure 8/9/23 से later लगा हुआ है।
सेकंड काउंटर में लगाया वो।
नहीं, writ के विजयकांत writ में।
Lordship there. Annexure 5, which is under challenge. Lordship, may give a brief fact. The university's counter is also required in this case, which has not been filed.
So you will not press IA? IA number 1688 of 2024, the learned counsel for the petitioner does not want to press this interlocutory application.
The judgment which you have
accordingly, IA number 1688 of 2024 is dismissed as not pressed. Counter affidavit has been filed by the state.
Yes, sir, it is.
Let the counter affidavit be filed by the university as well.
Come for the first time.
By 14th March, rejoinder by 21st, post on 8th of April. Under the heading for admission.
Item 44, WPS 6110 of 2023.
Before going to the merit of the case, Your Lordship, my humble prayer is that Your Lordship, before this honorable court, may direct respondent number 2 to dispose the representation filed by the petitioner.
You are challenging some order.
Yes, Your Lordship.
Then why representation? How she can dispose of the representation when there is an adverse order against you?
In the representation, Your Lordship, entire merits of the case was elaborated.
Then you don't want to challenge the impugned order. I will record that you don't want to challenge the impugned order.
No, Your Lordship.
You don't want to
Then,
challenge.
no, I am going to challenge the.
Then such kind of order cannot be passed. Learned counsel for the parties are present. The learned counsel for the respondents is directed to seek instructions and file a counter affidavit by 14th March. Rejoinder if any by 28th. Post this case on 8th of April 24 under the heading of admission. Next.
Item 45. Item 45, WPS 6119 of 2023.
The prisoner has paid for a direction of the respondents to pay the arrears of salary for the period from 23/5/2015 to 31/10/2021.
Same order. Counter. Next.
Item 46, WPS 6127 of 2023.
A counter by 14th, rejoinder by 20th, and on 8th of April we are posting it. Yes, petitioner? Petitioner absent, post tomorrow. Next.
Item 47, WPS 6161 of 2023.
Petitioner?
The present writ is for compassionate appointment of in lieu of death of her father and brother.
What is the date of death?
The date of death is 2009. Initially, FIR was registered in the year 2009, in which my lord, the petitioner father and brother was died in the.
Have you got a declaration?
Yes, my lord, I have filed the.
Have you got a declaration from the civil court of civil death?
No.
They were missing. dead body was not recovered.
Recovered?
Dead body was recovered.
It has come in the case diary my lord during investigation.
Okay.
That was identified by the informant also my lord.
So in the year 2009, your father and brother have expired.
Yes.
What is the cause of action to file the case in 2023? When did you file your application? What was your age at the time of death?
The time was
2009.
thereafter final form.
What was your age at the time of death?
So far the age is concerned, my lord. I have to.
Counsel for the petitioner is not ready post-mortem. सब पता करके आइए. What was the age? If you were minor on the date of death, you are not entitled to any relief.
No, I was not minor.
We do not know. You are not able to answer the query of this court. You come tomorrow. Get ready.
Item 48, WPS 6162 of 2023.
Petitioner.
The provision in as contained in Annexure 1, which is still continuing in Bihar enacting provision. For fourth period, there would be limited examination of 25%. Otherwise, 50% posts are reserved for promotion from grade 4 to grade 3.
You file your contract.
The leadership, the cause of action is of the year 2008 and they have filed the writ in the year
Still, appointment is going on, and Chief Minister has directed.
They were sitting up.
Chief
There's
Minister,
nothing on record that they have represented before any authority. Just that they have filed one annexure whereby they are stating that they have represented in a Jan Samvad before the CM in the year 2016.
There has been fresh recruitment thereafter.
That is.
You file your contract. You file it shortly. You want less time?
3 weeks.
The same by 14th you file rejoinder by 20th and on 8th same order. On 8th April it will come.
Item 49, WPS 6224.
8th April को final disposal के लिए करते हैं. Yes, petitioner. Yes.
Lordship, this is in this red petition. The petition.
21 of 2016.
Yes. There are some matters already pending.
No, we are not concerned. You just tell us.
I guess.
That how we can pass any order contrary to the directions of the honorable.
No, it is not in contrary. It is in pursuance to the order passed by the honorable Supreme Court. It is regarding those candidates who were in the first lot who were given appointment. The petitioner has stated in para 12 that she has obtained more marks, and if the seat is vacant in her particular district, then her candidature can be considered. Now, similar matter is pending before your lordships only in WPS 4431 of 23.
What is the relief that you are seeking?
Yes. For consider the candidature of petitioner in the merit list and appoint her in accordance with law in connection with advertisement number 21 of 2016. In view of the decisions passed by the Honorable Supreme Court in Civil Appeal number, that is the Soni Kumari judgment of 403822, as well as the contempt case 612 of.
Fresh merit list must have been issued by them.
Yes, but
right?
Still seats are vacant, and that is
no,
under
we
consideration.
cannot pass any such order. Because there is a clear order by the Honorable Supreme Court that no further order is required to be passed by the High Court.
Your Lordship,
We cannot commit contempt,
yes.
Right?
Your Lordship, on that, I'm only
You just tell us how can we pass an order which is contrary to the direction of the Honorable Supreme Court. Where is the order in the contempt case? You must have annexed it.
No, that has not been annexed.
You mention it and you don't annex it.
I guess the main that is.
WPS number 6224 of 23. Counsel for the petitioner. Post this case tomorrow. You get the orders, you just see it is very much mentioned in that.
Your Lordship, there is another 4431 of 23 before your Lordships only. And
it doesn't make any difference.
In that,
it doesn't make any difference.
Item 50.
You come tomorrow with the order.
Your Lordship, day after tomorrow, expect me.
Day after tomorrow, I'll just examine.
Day after tomorrow, there is no such bench.
Okay.
We are posting it tomorrow only.
Tomorrow.
Item 50, WPS 6295 of 2023.
Petitioner,
Yes. The list of dates. The press filing matter. The reply has been filed, and I would be praying for some time for filing a rejoinder because some points are required to be
WPS
responded.
number 6295 of 23. Counsel for the petitioner prays for and is granted time till 21st March 24 to file a rejoinder to the counter affidavit. Post this case on 8th of April. Under the heading for
Relying
admission.
upon
Next.
advertisement which has been examination has been held by JSSC, and JSSC is not a party in this.
We do not.
No,
You just submit
JSSC has no
whatever.
concern. No relief has been sought for against JSSC. Just go through the records.
Item 51, WPS 6506 of 2023.
Petitioner,
Whether we have to grant the ACP benefits from the dates followed.
you are seeking Sheshurari, file your counter. Same order. Counter by 14, rejoinder by 28, post on 8th April under the heading for admission. Next.
Item 52, WPS 6653 of 2023.
Petitioner is a widow. Counter affidavit has been filed. The thing is, one of the petitioner is seeking compassionate appointment and death benefits arising out of the death of her deceased husband who died in the course of duty, madam. While he was posted at a Naka, he was trying to stop a vehicle for.
Post this case tomorrow?
Yes.
We'll hear it tomorrow. Come ready. Give me the list of dates.
Yes, sir.
Basic list of dates. You can just mail it to us.
Item 53, WPS 6792 of 2023.
There is no counter has been filed. The matter relates to the petitioner. His name was considered. This is relating to a college which was taken over as constituent college in the fourth
File
state.
your counter affidavit. Respondents, state as well as university are directed to file counter.
State is the main party because the input
Let
order
the
is
counter
passed.
affidavit be filed in the present case by the state as well as the university by 14th, rejoinder by 21st, post on 8th of April under the heading for admission. Next.
Item 54, WPS 6793 of 2023.
Your Lordship, I pray for a short pass over.
Lordship, counter is required in this case.
Same order, counter. Next.
Item 55, WPS 6815 of 2023.
Counter has been filed by the state, my lord, I need to file it.
वो rejoinder वाला जो order किया है ना? Same order. Next.
A date may be.
आज तक इस केस में इस कोर्ट में ऑर्डर सुने हैं जिसमें डेट नहीं फिक्स हो.
Item 56, WPS 6881 of 2023.
Yes, petitioner. The respondents are directed to file a counter affidavit in the present case and it's in date with the gradation list. Counter affidavit be filed by 14th, rejoinder by 20th, post on 8th of April under the heading for admission.
Item 57, WPS 6886 of 2023.
Yes, petitioner.
The petitioner is not entitled to the relief as he is doing the application.
You have filed your counter?
Yes, yes. Ladyship, page 28 of my counter affidavit. These are the rules, your Ladyship, being the
As per the rules, he is not entitled.
Yes, 13 rule 1, an untrained teacher shall not be eligible for promotion to any of the grade that is 1 to 8.
A counter affidavit has been filed, post tomorrow.
Alright.
Next.
Item 58, WPS 6889 of 2023.
Yes, petitioner.
सिक्स से लेके
56 में हम लोग क्या किए?
काउंटर का हुआ है 14 तक फिर 8 तक फिर
8 उसमें तो काउंटर नहीं है, इसमें काउंटर आ चुका है, इसमें भी काउंटर आ चुका है, इसमें भी काउंटर affidavit has been filed post-mortem. Let's see what happens.
Item 59, the rupees 6892 of the 123.
Promotion matter 1993 promotion rule.
No counter filed.
Counter has been filed.
We are posting it tomorrow. Let us see what happens.
Item 60, the rupees 6894 of the 123.
They are seeking for promotion.
No counter filed.
Counter is only one.
You file counter. Same order. Counter by 14. Rejoinder by 20.
46 में appear नहीं कर पाएंगे।
क्या करना?
Serial 46.
कल आ जाइएगा।
No one केवल
कोई बात नहीं, कुछ नहीं होने वाला है। कल आप आ जाइए 10:30 बजे।
The matter has been listed at 3839 for daily tomorrow. We are directed to file a supplementary for the personal service. We are seeking permission. So
File it, please. File it.
much already, my lords. Much already.
खत्म।